Is it time to remove absolute immunity from the judicial branch? Politics is poisoning the judiciary. The American Revolution ended the rule of royalty in the former British colonies. The result was that monarchy in the colonies was replaced with the U.S. Constitution that came into effect in 1789 and created the current Federal Republic. Democratic principles replaced the rule of hereditary-based monarchy with its traditions and trappings. In this democratic goal, the country has been largely successful. The one glaring exception is the role of the judge in the judicial branch in the various jurisdictions in the country, federal, state, local jurisdictions. Judges hold near absolute monarch-like status within their court, from the attire to the unfettered power they hold within the courtroom, and though the system has generally worked well, it appears that it is no longer to be the case. In current times, there has been a significant number of examples of abuses, especially in these politically charged times, where the complete removal or significant rollback of absolute immunity for judges needs to be considered. In nearly all jurisdictions, judges and many of the court officers are granted absolute immunity. This means that judges cannot be held civilly liable for their official acts, even if they are acting maliciously or corruptly. In some instances, and in some jurisdictions, there can be claims made to seek injunctive relief, but that often requires going to an appeals court and relying on that court to decide if they will take the case or not. But the judge is not punished either. This means that most decisions made by judges are not subject to any oversight of their actions, no matter how malicious, and in many cases cannot be criticized under the threat of a gag order or a contempt of court charge, meaning fines or jail time. A judge over a case and within its courtroom has the most powers that experienced since the monarchy rule. The U.S. Constitution grants federal judges lifetime appointments, which means they can make decisions without fear that their decisions will be subject to partisanship or mob pressure. The Constitution does allow federal judges to be removed using the constitutional impeachment process. Despite this, the threat of impeachment has turned out not to be a deterrence, because only 8 federal judges have been removed from the bench since 1789. The U.S. Senate, which must approve all federal judges' appointments from the president, used to require 60 out of 100 vote threshold to be approved for the bench. This meant that most federal judges had to be acceptable to both parties prior to being elevated to their lifetime appointment. This process was able to remove most of the candidates that were hardcore partisans or ideologues from serving on the bench. This rule was removed by Senate Majority Leader Harry Reid, Democrat of Nevada, in 2013 in what was called the nuclear option. And now all federal judge positions only require a simple majority approval, which means that the party that runs the U.S. Senate determines who can get approved. The result is that political party partisans and activists can be elevated to a lifetime appointment with no fear of oversight or repercussions for injecting political bias into rulings before the court. States and local jurisdictions have different rules for judges, but for the most part, instead of lifetime appointments, judges are elected. The open judge positions usually have office qualifications, such as have a law degree and be in good standing to practice law in the state to be eligible to run for that judge seat. Magistrates usually have a different requirement than trial judges, but it's pretty much an election process. Election of judges means that they can be subject to partisan pressures and fundraising while running for election, or will be aware that their decision may have repercussions to their re-election. In a hyper-partisan political environment that exists in many jurisdictions today, it means that a judge can run on partisan issues and act out on those issues to satisfy the electorate that put them in their position. Wisconsin's 2023 Supreme Court election is a good example. This means that a judge can become an activist if they are in a safe partisan district and not have to be concerned about the repercussions due to them having absolute immunity from abuses they may inflict on their political opponents or act out on their own personal or political bias. The use of judicial oversight from the various appeal and Supreme Courts are not necessarily a deterrent either. If an appeal of a ruling is taken up by another court, a majority or not, there are no sanctions against the judge being reviewed if they have their rulings overturned. Judges, for the most part, make their own determinations that they are requested to recuse themselves due to conflict of interest. Lower court judges have also ignored court rulings, and again do this with no fear of repercussions. Hawaii versus Wilson is another example. Or they ignore constitutional protections themselves by forcing searches or gagging criticisms from people involved in the court case. The lack of accountability from higher level courts, the breakdown of standards from the Senate, the injection of partisan issues in federal, local, and state judicial elections, no threat of impeachment or recall, and the near autonomy of judge within their court has created a real threat of judicial activism and promoting of lawfare, which is using law to punish or harass political opponents. The result is that the judicial branch is just as broken as other branches of government. Fidelity to the law has becoming secondary to desired outcomes that cannot be won at the ballot box and punishing political appointments. If the judicial branch wants to have its rules viewed as a legitimate and not Soviet-style outcome, there needs to be reforms to remove political partisanship and judicial abuse from the system. The removing of absolute immunity from judges could be a reform that can be used to correct the course of the judicial branch and return the fidelity to the law and constitutional protections. If a judge can be subject to a monetary liability for their abuse of power, it could change outcomes of decisions. For example, would New York Judge Arthur Engoron issue a $454 million ruling against former President Trump in a civil fraud trial if he could be subject to civil liability for issuing gag orders, fines for statements made inside and outside of the court, issuing a judgment with no trial, and declaring liability before the trial even starts? Current absolute immunity means that Judge Engoron's decisions cannot be reviewed or sanctioned for potential violations of the First Amendment, the Seventh Amendment, and the Eighth Amendments of the Constitution. Would the threat of a civil suit make him more judicious in his rulings, knowing that depriving a party of their constitutional rights subject him to civil liability? The New York law that was used against President Trump does not require a victim, which means there is no standing to bring a suit. So would removing a judge's immunity from liability put the brakes on such laws from being used in their courtrooms? Nearly all actions in the U.S. can be subject to civil liability, from a car accident, making prejudicial decisions, to faulty products sold to customers. This can be subject to abuse, but it does create a tempering process to actions that could be detrimental to other parties. Judges and court officers were one time thought to be above this, but have proven themselves more and more to be political actors who serve their party interests and personal biases above fidelity to the law, and use the power of the court to do what cannot be obtained through the voting process. The judiciary is moving into territory where it has violated its bestowed institutional trust with more and more commonality that it no longer deserves the benefit of absolute immunity.